Inventory report on jurisdictional status of federal areas within the states. 1. Authority. This inventory report on jurisdictional status of federal areas within the states, as of June 30, 1962, is the second comprehensive inventory of its nature ever undertaken. It has been prepared and issued by General Services Administration pursuant to the author. ITY contained in the Federal Property and Administrative Services Act of 1949, as amended. The compilation of the 2. Background, or Einal Inve A8 June 30th. 1957, constituted a step toward fulfilling the hope expressed by the President in a letter dated April 27, 1956, to the Attorney General, that General Services Administration established Central source of information concerning the legislative jurisdictional status of federal properties. An interagency committee consisting of representatives QF, Department of Justice, Bureau of the Budget, and General Services Administration was formed to maintain a continuing and concerted interest in the progress made by federal agencies in adjusting the status of their properties. This committee requests DIDA, Administrator of General Services, to compile a second inventory on the jurisdictional status of federal areas within the states, as of June 30, 1962. The committee to add the new inventory necessary in order to refine legal determinations in the original inventory, as of June 30, 1957, and, further to include data on federal holdings in the new states of Alaska and Hawaii as well as new acquisitions in the other states. Article 1, Section 8, Clause 17, of the Constitution provides that the Congress shall have power to exercise exclusive legislation in all cases whatsoever over such district not exceeding 10 miles square as may, by cession of particular states, and the acceptance of Congress, become the seat of the government of the United States, and to exercise like authority over all places purchased by the and of the legislature of the state in which the same shall be, for the erection of forts, magazines, arsenals, dockyards, and other needful buildings, emphasis added. Exclamation mark. 1. It is well known that under the first portion of this constitutional provision the federal government exercises with respect to the District of Columbia all those powers, judicial, executive, and legislative, which under our federal state system of government are ordinarily reserved to the states. It is not so well known that under the second portion of this constitutional provision, the portion that has been emphasized above, the federal government has acquired, like authority, with respect to numerous other areas within the geographical confines of the states and with respect the residents of such areas. These other areas, sometimes called enclaves, are, in effect, federal islands surrounded by state territory, to the extent that jurisdiction thereover has been surrendered to, and accepted by, the federal government. The states are deprived of the ordinary authority of a state and cannot, with respect to such federal enclaves or to their inhabitants, exercise usual state functions. But, while the Congress has legislated complete civil and criminal codes for the District of Columbia and provided the local machinery necessary for the administration and enforcement of those codes, it has legislated little, and provided little by way of local governmental machinery, for such federal enclaves or for their inhabitants. Over the years, the peculiar legal status of the federal enclaves has given rise to many serious problems. The significance of those problems is being magnified as the impact of governmental action on the individual citizen continues to mount. In the past, such pro quo gems were handled on a case-to-case basis. In December of 1954, upon the recommendation of the Attorney General and with the sponsorship of the President and the Cabinet, an interdepartmental committee was formed to study the entire subject of legislative jurisdiction of the federal government over areas within the states and to make recommendations thereon. The extension of the federal government's jurisdiction over lands within the states and over the residents of such lands was slowed down with the removal on February 1, 1940, of the federal statutory requirement originally enacted in 1841 that, in the case of purchased land, the consent of the state to such purchase be secured prior to construction of any federal building thereon, the acquisition of jurisdiction by the federal government was further slowed down with respect to newly acquired lands by the findings of the above-mentioned committee. However, there does not now exist any administrative machinery for canceling the legislative jurisdiction previously acquired by the federal government from the several states. 3. Objectives. The Interdepartmental Committee for the Study of Jurisdiction over Federal Areas within the states made the following conclusions and recommendations. 2. 1. In the usual case there is an increasing preponderance of disadvantages over advantages as there increases the degree of legislative jurisdiction vested in the United States. 2. With respect to the large bulk of federally owned or operated real property in the several states and outside of the District of Columbia, it is desirable that the federal government not receive or retain any measure whatever of legislative jurisdiction, but that it hold the installations and areas in a proprietorial interest status only, with legislative jurisdiction remaining in the several states. 3. It is desirable that in the usual case the federal government receive or retain concurrent legislative jurisdiction with respect to federal installations and areas on which it is necessary that the federal government render law enforcement services of a character ordinarily rendered by a state or local government. These installations and areas consist of those which, because of their great size, large population, or remote location, or because of peculiar requirement based on their use, are beyond the capacity of the state or local government to service. The committee suggests that even in some such instances the receipt or retention by the federal government of concurrent legislative jurisdiction can, and in such instances should, be avoided, and 4. In any instances where an agency may determine the existence of a requirement with respect to a particular installation or area of a legislative jurisdictional status, with a measure of exclusivity of jurisdiction in the federal government, it would be desirable that the federal government in any event not receive or retain with respect to the installation or area any part of the state's jurisdiction with respect to taxation, marriage, divorce, annulment, adoption, commitment of the mentally incompetent, and descent and distribution of property, that the state have concurrent power on such installation or area to enforce the criminal law, that the state also have the power to execute on the installation or area any civil or criminal process, and that residents of such installation or area not be deprived of any civil or political rights. These recommendations were concurred in by the President in a letter to the Attorney General dated April 27, 1956. The principal objective of preparing this inventory is to provide a central source of information concerning the legislative status of federal properties. 3. Another objective is that of providing a means for observing the progress made by all federal agencies in adjusting the status of their properties in conformity with the recommendations of the above-mentioned Interdepartmental Committee. This is in keeping with the President's letter of April 27, 1956, asking that General Services Administration, with the Bureau of the Budget and the Department of Justice, maintain a continuing and concerted interest in such progress. 4. Source of data. This inventory of jurisdictional status is based upon the determination of status by the various federal agencies with respect to the areas under their respective control. These agency determinations of jurisdictional status were reported to GSA pursuant to General Services Administration Circular No. 2 feet 75, dated July 18, 1962, copy of which follows. Data with regard to the jurisdictional status of federal land were obtained by the agencies, principally from title papers and O-her basic documents. The determinations are subject to change through the revaluation of information now on hand, or upon the basis of additional facts that may become known. 5. Scope. This inventory report shows the legislative jurisdictional status, as of June 30, 1962, of lands located in each of the 50 states, in which title is vested in the federal government or in wholly owned government corporations. It covers, with respect to those 50 states, the same land areas that are covered by the Inventory Report of Real Property owned by the United States throughout the world, as of the same date. Department of Defense military functions reported only summary data for its land holdings in Alaska and Hawaii. 6. Areas not covered. The whole of the area now constituting the District of Columbia is under the exclusive jurisdiction of the United States. It embraces, except for certain adjustments, the area that was ceded by the state of Maryland to the federal government for the purpose of establishing the seat of the government and accepted by the federal government in 1790, the area that was ceded by the state of Virginia for that purpose and likewise accepted was retroceded to that state. In 1846, these two areas together approximated the 10 miles square that is referred to in the first portion of Article 1, Section 8, Clause 17, of the Constitution. However, the District of Columbia, as the seat of the government, involves special considerations not generally applicable to other federal areas. Accordingly, the above-mentioned Interdepartmental Committee restricted its report to those areas that are covered by the like authority and did not deal with the District of Columbia. The same considerations have led to the exclusion of the District of Columbia from this report. 4. Inasmuch as the legislative jurisdiction involved in this report concerns the authority of the Federal One government in relation to that of a state, this report does not deal with property in the territories or possessions, or in the Commonwealth of Puerto Rico. 7. Definitions. Article 1, Section 8, Clause 17, of the Constitution speaks only of exclusive jurisdiction or, to use the exact language, the power to exercise exclusive legislation, in the absence of a uniform code of federal laws, for areas to which the federal government has acquired such exclusive jurisdiction, the operation of the jurisdiction transferred to the federal government with respect to federal enclaves and their inhabitants varies as between states, and even as between areas acquired at different times within a single state. Moreover, the Constitution has been interpreted as permitting the transfer of jurisdiction to the United States to be subject to a continuing jurisdiction of the state, either in all, or in certain limited aspects. In addition, the federal government has enacted various statutes to permit the states in certain cases to exercise limited jurisdiction over federal enclaves and their residents. These factors have led to an almost infinite variety of jurisdictional situations. For statistical purposes, federal areas are divided into 4 categories: are, where complete information is lacking, are listed as unknown. The 4 categories, and their definitions, are those shown in GSA Circular Number 275, which follows. It should be borne in mind that, while those definitions are based upon judicial decisions and administrative applications, they do not necessarily coincide with the meanings of the same terms as they are used in particular federal and state statutes. 8. Public domain. Unlike the inventory of federally owned real property, this inventory has not been compiled on the basis of whether the land is a part of the public domain or is after acquired land. Nevertheless, an explanation of the special status of public domain lands is warranted. The term public domain, as it applies to land within a state, refers to those lands which were acquired by the United States prior to the creation of the state and which are still retained by the United States, such as lands acquired by the federal government by virtue of the Louisiana Purchase. The term has no application to any land in the original 13 states, or in Texas, which was an independent state prior to its admission to the Union, and at present has only limited application to land in the states 5. Created out of the territory that belonged to the original 13 states. Public domain lands are to be differentiated from so-called after acquired lands, which exist in every state. Much of what was originally public domain is now in private ownership through operation of the homestead laws and other similar laws. Other portions of the public domain have been withdrawn or reserved for military or other public uses. A state statute providing the constitutional consent to the purchase of lands by the United States, as opposed to a status directly ceding jurisdiction to the United States, would not operate to vest exclusive jurisdiction in the United States over public domain lands, inasmuch as the public domain, by definition, does not embrace land that has been purchased by the consent of the legislature of the state in which the same shall b. Moreover, in only a few states, such as Arizona, Nevada, and Utah, do the direct cession statutes of general application provide for exclusive jurisdiction in the United States over public domain land that is reserved for public uses. Also, in only a few cases, such as that of Yellowstone National Park, has exclusive jurisdiction for the United States been reserved in the Enabling Act by which the state was created. As indicated above, the statistical aspects of this report do not distinguish between public domain lands and after acquired lands. 6. General Services Administration, Washington 25, D.C. General Services Administration Circular No. 215. 2. Heads of Federal Agencies. Subject: Inventory of legislative jurisdiction over federal areas within the states. 1. July 18, 1962. Purpose: this circular prescribes 8 reports necessary for the compilation of an inventory of the legislative jurisdiction over federal areas within the states, as of June 30, 1962, and B forms, with detailed instructions for the preparation and submission of these inventory reports to the General Services Administration by the reporting agencies. 2. 3. Background: in conformance with the President's request of April 27, 1956, published in Part 1 of the Report of the Interdepartmental Committee for the Study of Jurisdiction over Federal Areas within the States, an inventory showing the legislative jurisdictional status of each federal installation was compiled, as of June 30, 1957, and a summary inventory report prepared and presented to the President on November 10, 1959. The summary inventory report was published and released to the public December 2, 1959. An interagency committee consisting of representatives of Department of Justice, Bureau of the Budget, and General Services Administration was formed to maintain a continuing and concerted interest until the progress made by federal agencies in adjusting the status of their properties. This committee requested the Administrator of General Services to compile a current inventory on the jurisdictional status of federal areas within the states, as of June 30, 1962. The committee deems the new inventory necessary in order to refine legal determinations in the original inventory and, further, to include data on new federal land holdings and data on the newest states, Alaska and Hawaii. Reporting agency: a reporting agency, for purposes of this inventory, is the same as that used for the inventory of real property owned by the United States government, as defined in GSA Reg. 2XI20L.0L, dated November 8, 1960. 7. 4, 5, 6, 7, 8. Coverage: the inventory prescribed by this circular shall cover all land located in each of the states, title to which is vested in the United States or in wholly owned government corporations. The coverage of land for this inventory shall be identical with the inventory of real property owned by the United States, for land in the United States, as prescribed in GSA Reg. 2XI20L.00, dated November 8, 1960, except that it shall omit land located in the District of Columbia and land held in trust for others. Reports to be submitted: each reporting agency shall prepare, in accordance with instructions in Attachment LA, and submit to the General Services Administration, a separate report on GSA Form L166B, Report of Legislative Jurisdiction over Federal Areas within the States. Attachment 1 for each federally owned installation in the United States, as of June 30, 1962, excluding those in the District of Columbia and those held in trust for others. Each reporting agency shall also prepare in accordance with instructions in Attachment 2A, and submit to the General Services Administration for each bureau or other major organizational unit, a report on GSA Form L209B, Summary Report, Legislative Jurisdiction over Federal Areas within the states. Attachment 2. GSA Form L209B shall also be used for reporting summary data on the nature and number of non-federally owned lands over which the federal government has any legislative jurisdiction. However, non-federally owned lands in national parks or forests or other similar areas over which the federal government has acquired no special jurisdiction from the states shall not be included. An original and 2 copies of each report shall be submitted to the General Services Administration, Office of Finance and Administration, Accounting and Reports Management Division, General Services Building, Washington 25, D.C., not later than January 1, 1963. Optional reporting method. Reporting agencies which have electrical accounting machine equipment may make arrangements with the General Services Administration, Office of Financial Management to furnish detailed machine listings, together with the supporting punch cards, in lieu of GSA Forms 1166B. However, GSA Forms 1209B shall be submitted as prescribed in Section 5, above. Supplies of forms. The June 30, 1962, revision of GSA Forms L166B and 1209B may be obtained after August 1, 1962, from General Services Administration Region 3, Office of Regional Finance and Administration, Reproduction and Distribution Division, General Services Regional Office Building, Washington 25, D.C. 8, 9. Agency Liaison. The agency liaison representatives on real property inventories, designated pursuant to GSA Reg. 2XI Lul.06, dated November 8, 1960, shall also serve for purposes of this inventory. If desired, a special agency representative may be designated for purposes of this inventory of legislative jurisdiction over land areas. When an agency designates a special representative for this inventory, it shall be his responsibility to coordinate all reports with the regular real property liaison representative, the General Services Administration, Office of Finance and Administration, Accounting and Reports Management Division, General Services Building, Washington 25, D.C., shall be advised in writing of the names of all such special liaison representatives or any changes in such designations. Inquiries. For additional information regarding the contents of this circular or any questions or problems relating thereto, agency representatives may communicate with the General Services Administration, Office of Finance and Administration, Accounting and Reports Management Division, Washington 25, D.C. Telephone, Government Dial Code 183, Executive 34900, Extension 4131. Bernard L. Boudin, Administrator. Addicments. 9. GSA Wash DC 131022. Attachment 1. GSA Circular No. 275. General Services Administration. Report of legislative jurisdiction over federal areas within the states. For instructions see GSA Circular Number 275. 4. Name of